Hello, my name is Emma Snape, Special Event and Program Manager for the Maltz Museum of Jewish Heritage. On behalf of everyone at the museum, welcome to our virtual program, Virtual Gallery Talk, Jonathan Entin on Ruth Bader Ginsburg's early career. This program is inspired by our newest special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, presented locally by PNC Bank. Today, I'd like to give a very warm thank you to PNC, our #1 sponsor for the event, and also to all of our sponsors and partners for the overall exhibition, as well as today's program, including today's special programming partner, the Nancy and David Wolf Holocaust and Humanities Center. If you're interested in learning more about some of the court cases that Jonathan will be talking about today, Cincinnati's Holocaust and Humanities Center is hosting more information about the Frontiero versus Richardson case in their Humanity Gallery. And many of the cases are also covered in the Notorious RBG special exhibition at the Maltz Museum. We have the exhibition through August 29th, and until that day, we are welcoming visitors to join us safely in person, Wednesday through Sunday from 10 a.m. to 5 p.m. We're using best practice protocols, such as wearing masks and maintaining social distancing to ensure a safe visiting experience. Of course, we also welcome you to explore the Notorious RBG from the comfort of home. On the first and third Tuesday of the month at 2 p.m., we offer a virtual online tour of the exhibition, or you can still bring a group for a private online experience through the 29th. You can learn more about ways to connect through our website, www.maltzmuseum.org. I'm so glad that you've already connected with us and that you're here today for our gallery talk with Jonathan Entin. In today's program, Jonathan will discuss some of the early cases of RBG's career, drawing on his own experience as her law clerk. Now I'm going to introduce Jonathan, and then after that, I'm going to let him take it away, what we're all waiting for. Jonathan L. Entin is the David L. Brennan Professor Emeritus of Law and Adjunct Professor of Political Science at Case Western Reserve University. Professor Entin was a law clerk to Justice Ruth Bader Ginsburg when she served on the U.S. Court of Appeals for the District of Columbia Circuit. He has written extensively about constitutional law and civil rights. His teaching awards include the Distinguished Teacher Award from the CWRU Law Alumni Association, and 4 graduating classes named him Teacher of the Year. 2 others honored him as Administrator of the Year when he was the law school's academic dean. He continues to teach and write while serving as the university's faculty mediator. And now, without any further ado, Jonathan Entin. Thank you, Jonathan.
Thank you, Emma. Let me unmute my, okay. Thank you. The first thing I want to do is to thank you and the museum for asking me to be part of the program. The second thing I want to do is to encourage any of you who have not yet seen Notorious RBG at the museum to do so before the exhibit closes on August 29th. It is a wonderful exhibit. Now, I was privileged to know Ruth Bader Ginsburg for more than 40 years. As Emma said, I was one of her earliest law clerks, and I stayed in touch with her over the years after that. Now, I applied to be a law clerk for then Judge Ginsburg precisely because she was a distinguished legal scholar who had also directed a remarkable litigation campaign that fundamentally transformed the law of gender discrimination. Now, I should say I did almost everything wrong in applying for this clerkship. Just to give you a sense, I mistakenly thought that she was already a judge when I sent out my application, so I mailed it to her in Washington, D.C. at the courthouse. A while later, I got a nice letter back from her on her Columbia Law School letterhead, explaining that, in fact, her nomination had only recently gone to the Senate, so she wasn't obviously a judge quite yet. But she asked me for some additional information, and eventually she invited me to come to her home in New York for an interview. Now, that was before she was confirmed and when it was far from certain that she would be confirmed. This was, after all, June of 1980. It was an election year, and you can imagine some of the political maneuverings that might have been going on. But on the morning of June 18th, I arrived at her place a little after 9:30 in the morning. When I got there, her then 15-year-old son, James, greeted me by saying, "I was going to ask you why you want a clerk for an unconfirmed judge, but I can't do that. She just got off the phone. The Senate confirmed her a few minutes ago." So I was the first person outside the family she saw after getting this news. We talked for a while. The conversation was interrupted regularly by congratulatory phone calls as the news got around. And after a while, she made me the offer, which I was delighted to accept. Now, that was 1980. I had one more year of law school. And during that year, she made sure that I received all the decisions from the DC Circuit so that I would know what the court had been up to when I started my clerkship. During that year, she even welcomed my having caught a faulty citation in one of her opinions. Now, I have a picture. Will, can we put the first picture up? I have a picture of the Chambers community that I'd like to put up. You can see the judge seated in the middle, and you can see me 40 or so years ago in the light blue suit. But let me just say something about the other folks in the picture. The tall fellow standing over the judge's right shoulder is my co-clerk, Gary Harris. Gary recently retired as a partner at a very prominent New York-based law firm. And seated immediately to the justice's left is Monica Wagner, my other co-clerk. Monica has had a very distinguished career as a lawyer, mostly in Washington, more recently in New York, where she also has been an adjunct professor at Columbia Law School. The other two people in this picture are really important. They were Judge Ginsburg's staff. The person seated directly to the judge's right, Linda O'Donnell, she was relatively new when I got there, but she stayed with Judge Ginsburg for the rest of her time on the Court of Appeals and went with her to the Supreme Court and stayed there for a good long while. The other person in the picture standing directly behind the judge is Eleanor Gomberg. Eleanor was more senior, and she really functioned as the office manager. In doing so, she continued in a role that she had played for the judge's predecessor. And maybe that's why Eleanor told the first set of clerks, the ones who started when Judge Ginsburg joined the Court of Appeals, that they couldn't leave the office while the judge was still there. Now, Justice Ginsburg was not a morning person. Indeed, I rarely saw her before 10 o'clock on any morning when she wasn't scheduled to be on the bench to hear arguments. And she worked really late. One evening around 7 o'clock, she came out of her office to get a cup of coffee and saw that all the clerks were still there. She asked why they were at their desk at that hour. They told her that what Eleanor had said about not leaving while she was still in chambers. The judge laughed and said she didn't have any such rule. Actually, all she really cared about was that the clerks got their work done on time and really well. Okay, we can probably take this one down. Well, thanks. But this notion that there weren't working hours or a dress code or anything like that, that kind of captures the essence of what made her such a wonderful boss. She wasn't a schmoozer, but she treated us like professionals. She did have a few ground rules besides getting the work done on time and getting it done well. The most basic one was that she wrote her own opinions. Her name went on them, and she wanted them to reflect her own voice. Now, she eagerly shared drafts and often incorporated our suggestions, but for the most part, the clerk's writing consisted of memos to the judge. Toward the end of the year, she'd let us do the first draft of an opinion or two. Our drafts came back covered with her editorial comments. And some of our words actually did survive, but that wasn't what we were aiming for. She gave us more latitude with the short memoranda that the court issued as unpublished opinions. But even then, her style was evident. Now, when we weren't helping her with opinions, we helped to prepare her for the next round of oral arguments. Each judge on the court would sit for several days each month to hear arguments, typically in panels of 3. The clerks in each chambers would divide up the cases that would be argued in each sitting, and we would write bench memos on every case before it was argued. Those memos provided an overview of the issues, explained what had happened in the case before it got to the Court of Appeals, and provided an overview of the parties' arguments. We focused on whether the arguments were supported by the record in the case and whether the authorities on which the parties relied actually supported their claims. Let's just say that we sometimes saw what you might call creative lawyering in that regard. Now, we also saw some terrific lawyering, but we couldn't count on that. Then a few days before argument, she would meet with each of us to discuss our cases. Well, my first bench memo was in a complicated election law case. I approached that project with more than usual trepidation. As I mentioned, I think she knew Gary and Monica from Columbia. Both of them had been her students. Monica had been her research assistant. I, on the other hand, had no prior connection with the judge, so I figured I had to prove myself. I wrote a 35-page bench memo that covered every imaginable aspect of the case. When we met, the judge's first comment was, "Don't do that again." My heart sank. Here I'd blown it on the first try. No, she quickly reassured me that the memo was terrific, but she said, "You can't write memos like that on every case or you'll never sleep." So things kind of went okay from there. Another case that stands out in this regard was a libel suit that was filed against the Washington Post. Now, the case came up on a really technical procedural issue, nothing to do with the merits, but the briefs were completely over the top. Well, we talked about the legal issues in the case, and then the judge remarked about the harsh tone of the briefs. I said, I had a hunch about what might be going on. One of the plaintiffs in that case was George Preston Marshall Jr., whose father was the founder and longtime owner of what until recently was known as the Washington Redskins. The Post was represented by a prominent Washington firm, Williams and Connolly. The Williams in that firm was Edward Bennett Williams, who owned the Redskins after Marshall Sr. Those two men detested each other. And I suggested that the terrible personal relationship between Marshall Sr. and Williams might have been reflected in the briefs. The judge listened attentively and then, in all seriousness, asked, "What are the Redskins?" And I think that, as I said, I think she was dead serious. Okay. Now, the clerk who worked on each case would then attend the oral arguments. We would take detailed notes about the proceedings and would be available to do quick research if anything came up during the argument. The judge always had incisive questions that got to the heart of each case, but she was always respectful of the lawyers, no matter how much they struggled. She even stayed calm one day when one lawyer responded to a question by asking her how she would answer the question, although you could almost see the steam coming out of her ears. And she did have views about the abilities of the lawyers who appeared before her. As I said, some of those lawyers were terrific, but not all. One of the cases argued on my very first day in the courtroom involved a tiny woman who had been beaten within an inch of her life by a coworker at work. The woman applied for workers' comp, but her application was rejected. At oral argument, Justice Ginsburg and the other two judges repeatedly asked her attorney what legal error the agency had made that would allow the court to overturn its decision. But the man never gave a coherent answer. When we got back to chambers, the judge said to me, if that woman paid that lawyer a penny, it was too much. At the end of each monthly sitting, she would serve us wine and cheese. After the first sitting, she was mortified to discover that she didn't have a corkscrew in chambers, so had to borrow one from one of her colleagues. When the holidays came around, she gave all of us very fancy corkscrews so that we would never be caught in that situation. And she stayed in touch with us after we left chambers. For many years, we had annual reunions that drew almost all of the former clerks, their spouses, and children. And she was always accompanied by her beloved Marty, a distinguished tax lawyer and professor in his own right, who was her opposite and complement in so many ways. She greeted all of us individually and talked to us briefly, but Marty was the life of the party. He had an infinite supply of great stories and kept things moving. Sometimes one of her judicial colleagues would serve as guest of honor. So, for example, for the 10th anniversary of her appointment, Justice Scalia came to speak. He was so well received that he was brought back for the 20th reunion. But it was more than reunions. For example, in one of my articles, I quoted something Marty had said at a congressional hearing. His comment appeared in bold-faced type on the front page of the Washington Post, and hundreds of T-shirts bearing that quote were distributed at the Internal Revenue Service. I alluded to that fact in the piece too. After reading the article, the judge found one of those T-shirts and sent it to me. And this is it. Let me read it to you. Okay. This was testimony on the 1982 tax bill. And Marty had said, the tax bar is a repository of the greatest ingenuity in America, and give them the opportunity, they will do you in. That quote actually worked for the point I was trying to make in the article, but I was amazed that she could find that. Okay, thank you, Will. We can take that out. Okay, now I had other opportunities to see Justice Ginsburg over the years. Occasionally when I was in Washington for other purposes, I'd have lunch with her. And she came to Case Western Reserve University's law school one year to speak and to preside at the final round of our moot court competition. She brought Marty with her. And when I picked them up for dinner, they were just overjoyed. They had spent the afternoon at the Cleveland Museum of Art, which had a painting that Marty had never seen the original of, although he'd seen copies. And he had seen copies because he had once represented a previous owner of the painting in a dispute with the IRS about its value. So Marty regaled us at dinner with the story of the hearing at which he had eviscerated the IRS appraiser, who turned out to know almost nothing about art. And just to give you a hint, when Marty asked him rather how the appraiser had got to the value, he said, well, I had a value per square inch, and then I measured the painting. So I multiplied the number of square inches by that rate. It turned out he had done the math wrong as well. Anyway, Marty could have did tell that story way better than I ever could. But in any event, The last time I saw Justice Ginsburg in person was when the law school had a ceremony for alumni and faculty to be sworn in as members of the Supreme Court bar. That ceremony took place in the courtroom. Justice Ginsburg graciously agreed to speak to us afterward, talking about other female judges who had marked the path for her. We also corresponded over the years. Unfortunately, I couldn't go to Washington for the memorial activities, but her staff arranged for those of us who couldn't make the trip to participate in a virtual vigil alongside the live vigil at the court. Now, before I wrap up, let me just say a few words about why I applied for my clerkship with the judge. I had been interested in civil rights and civil liberties and human rights for a long time. That's why I went to law school. And of course, Justice Ginsburg was a huge figure in that field. Let me begin, though, with Professor Ginsburg, the scholar. She made her mark early with significant articles on complex procedural subjects in leading law reviews, and both a highly regarded book and several other articles on Swedish law. Indeed, that work led to her receiving an honorary degree from the University of Lund that was presented to her by the King of Sweden. And she used to proudly display that diploma on the wall in her office. Now, beyond that, she published numerous pieces on constitutional issues, and she co-authored the first law school casebook on gender discrimination. Those latter projects grew out of her work as a lawyer, leading an effort to combat the gender discrimination that was pervasive in our law. Indeed, as the exhibit makes clear, that gender discrimination affected her in a very direct way. She spent her first 2 years at Harvard Law School. Marty was a year ahead of her, got a job in New York, and because they had a small child, who, by the way, is now a very prominent professor at Columbia Law School, she wanted to be with Marty and take Jane with her and take her third year at Columbia. But Harvard wouldn't give her a degree if she didn't spend her third year there. So she went and took her third year at Columbia. She was at the top of the class at Harvard when she left. She was at the top of the class at Columbia when she graduated. Somebody with a record like that would have been snapped up either right away by a Supreme Court justice or after a clerkship with a distinguished Court of Appeals judge. Nobody was interested in hiring her as a law clerk. No law firm in New York would hire her as a lawyer. So a lot of this was personal. Somebody with her record, it's just astonishing that she had the amount of trouble she did finding a job. But in any event, when she began her work against gender discrimination, the Supreme Court had never in its entire history found a sex-based law to be unconstitutional. But the court had had plenty of opportunities to assess the constitutionality of sex-based laws. For example, in 1873, the Supreme Court upheld the exclusion of women from membership in the bar. One of the opinions in that case, written by a supposedly progressive justice, said that women were just too fragile to be lawyers. The paramount destiny and mission of woman, wrote Justice Bradley, are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator. Now, sometimes the court refused to take gender discrimination claims seriously. So, for example, in a 1948 case that challenged a Michigan law that effectively prevented women from working as bartenders, the court's opinion began by saying, to state the legal question in this case is in effect to answer it. And as late as 1961, the court upheld the effective exclusion of women from jury duty because the court had explained women were the center of home and family life and couldn't disrupt domestic tranquility. Now, this changed in the 1971 case of Reed against Reed, which struck down an Idaho law that automatically chose men as administrators of estates over similarly positioned women. Ginsburg did not argue that case, but she wrote the brief, which is shown in the notorious RBG exhibit, and she worked closely with the lawyer who did argue the case. This seemingly small case, a tragic one involving the aftermath of a teenager's suicide, was the first time that the Supreme Court had ever found any form of gender discrimination to be unconstitutional. Now, she soon built on that foundation in a series of cases that she argued and others in which she wrote either amicus briefs or advised the lawyers who did argue. Can we get the Frontiero photograph? Her first oral argument was in Frontiero against Richardson, which Emma referred to earlier. This is Sharon Frontiero and her then husband Joseph. She was a lieutenant in the Air Force, and her case involved a law that, or an Air Force rule that said that if Joseph had been the soldier, that he could automatically have gotten housing and medical benefits for Sharon. But because Sharon was the soldier, she couldn't get housing and medical benefits for Joseph unless she could show that the husband, Joseph, relied on her for more than half of his support. That was her first case, and she won a really important victory and built on that in a couple of years later in a case called Weinberger against Weisenfeld. And can we get that first Weisenfeld picture up? Okay. This is Paula Polachek and Stephen Weisenfeld. They were married, and this case involved a provision of the Social Security Act that provided benefits to the widowed mother of a small child, but did not give the same benefits to the widowed father of a small child. What happened here? Paula died in childbirth, leaving Stephen to raise Jason. And this is a photograph of Jason being held by Stephen. Justice Ginsburg always said that Stephen Weisenfeld was her favorite client. He illustrated many of the problems that single parents have because there wasn't anybody else, and he had to take care of Jason, even if that interfered with his work. In any event, Stephen Weisenfeld testified at Justice Ginsburg's Supreme Court confirmation hearing, and in 2014, she performed Stephen Weisenfeld's second marriage. Actually, some years earlier, she had performed the marriage for Jason as well. And the exhibit has photographs of Jason with Justice Ginsburg on the occasion of the marriage, and another picture of Stephen and Justice Ginsburg. In 1976, Professor Ginsburg, as she was at the time, advised the lawyers and wrote an important amicus brief in the case called Craig against Bourne, which gave the modern constitutional standard for evaluating gender discrimination claims. It was an unusual case because it involved a state law requiring men to be 21 before they could buy low alcohol beer, but allowed women to buy that beer when they were 18. It was unusual both because the issue of buying near beer seemed pretty trivial, and also because the challengers were men. Now, there were other cases, and by the end of the 70s, by the time Ruth Bader Ginsburg was confirmed to the Court of Appeals in June of 1980, the Supreme Court had made clear that gender discrimination was no longer trivial, but required a substantial legal justification. Ruth Bader Ginsburg was primarily responsible for this dramatic transformation. Not only did she make creative and ultimately persuasive legal arguments, but she also devised a brilliant litigation strategy. She proceeded incrementally, sometimes, as in Weisenfeld and Craig, with male plaintiffs, and sometimes with married couples, as in Frontiero. She understood that the decision makers were those 9 older men in the Supreme Court. And she had to persuade them to take gender discrimination claims more seriously than their predecessors had. And she understood that those 9 older men might be more persuadable if she could show them that traditional notions of gender roles harmed men as well as women. And that's how she managed to have such an enormous impact. Now, let me just quickly add a few words about Justice Ginsburg's work on the bench. A lot of that's from the Supreme Court years is in the exhibit. And again, I encourage you to go there. But she spent 13 years on the DC circuit. And I just want to mention a couple of important cases from those years that have not gotten a lot of attention. One was a case called Wright against Regan. That case involved a group of Black parents whose children were attending public schools that were under desegregation orders. The parents sued the Internal Revenue Service, claiming that the IRS had been granting tax exemptions to whites-only private schools, which made it easier and cheaper for white parents to send their kids to the segregation academies, and that would frustrate desegregation. Well, while that case was going on, the Reagan administration was arguing in a case that was already in the Supreme Court that the IRS didn't have any authority to deny tax exemptions. And so Wright against Regan was going on actually partly during my clerkship. One morning, the judge came in very early, one of the very few days that she was in before 10 o'clock on a non-argument day. And she and her and 2 of her colleagues crafted an order that kept the Wright against Regan case alive while the Supreme Court was dealing with that other case. The other case I want to mention was a dissenting opinion that she wrote in 1988, a wonderful opinion in a case that was called In Re Sealed Case at the Court of Appeals and Morrison against Olson in the Supreme Court. That case grew out of a legal dispute involving Justice Gorsuch's mother, who was President Reagan's EPA administrator. And it involved the constitutionality of the independent counsel law. When the case was in the Court of Appeals, 2 of the 3 judges on the panel said that the law was unconstitutional. Judge Ginsburg wrote a terrific, thoughtful, detailed dissent explaining why the law should be upheld. The case wound up in the Supreme Court, which agreed with her in a 7-1 decision. I have taught Morrison against Olson for many years, and not because I clerked for Justice Ginsburg, but because the case is important. And I can tell you, Justice Ginsburg's dissent in the Court of Appeals is way better than the Supreme Court majority opinion. Now, just briefly, some things on her work on the Supreme Court that have not gotten as much attention as they might deserve. As I said, she was a brilliant lawyer and a shrewd strategist, and she brought that strategic sense to the Supreme Court, particularly in the last 10 years that she was on the court when she was the most senior of the liberal justices. She helped to keep that group unified in some high-profile cases, and sometimes that meant not writing even when there was plenty to say. For example, in the same-sex marriage case, Obergefell against Hodges, which, by the way, came up from Ohio, that was a 5-4 decision. Justice Anthony Kennedy wrote the majority opinion for the court. His opinion was unconventional in a lot of ways, and almost certainly any of the other justices in the majority would have written it differently. But none of them wrote a word. I strongly suspect that Justice Ginsburg had something to do with that. I'm confident that she would not have wanted to write separately because she wouldn't want to undercut the force of the decision by making it look like the justices couldn't agree on their reasoning. And I suspect that one way or another, she conveyed her view to Justices Breyer, Sotomayor, and Kagan. Similarly, last year, in a case called Bostock against Clayton County, which held that employment discrimination based on sexual orientation or gender identity violates Title VII, Justice Gorsuch wrote for a 6-3 court relying exclusively on an interpretive technique called textualism, which is especially attractive to conservative justices. But there are other ways to interpret statutes. None of the other justices in the majority said anything. And again, I think that was to try to avoid undercutting the force of the court's decision. Now, during her time on the court, most of the justices were appointed by Republican presidents. In fact, when Justice Ginsburg was appointed, she was the first Democratic appointee in 26 years. Even though she was in the minority, she wrote more than her share of opinions for the court, including in important cases involving redistricting, jurisdiction, environmental law, and copyright, for example. Most notably, she wrote for the court in United States against Virginia, which is shown in the exhibit that struck down the male-only admissions policy at Virginia Military Institute. And as the exhibit shows, she's probably better known for her dissents, like the one in the Lilly Ledbetter case, where she criticized what she called the majority's parsimonious reading of Title VII. If you knew Justice Ginsburg, that was about as strong a criticism as she could muster. And she urged that Congress amend Title VII to make it possible for cases like Lilly Ledbetter's to go forward in the future. Indeed, the Lilly Ledbetter Act was one of the very first pieces of legislation that President Obama signed after taking office in 2009. One of her other famous dissents was in Shelby County against Holder, which gutted a key part of the Voting Rights Act. Editorial comment: last month, the court significantly undercut the other major piece of the Voting Rights Act, but that's maybe a conversation to be had on a later day. Chief Justice Roberts wrote for the majority. Justice Ginsburg critiqued virtually every aspect of his analysis. You can get a sense about her view with the line that is probably most quoted from her dissent: throwing away this provision of the Voting Rights Act is when that provision has worked and is continuing to work to stop discriminatory changes to voting laws, is like throwing away your umbrella in a rainstorm because you're not getting wet. Again, you'll see that at the exhibit as well. Let me just wrap up by observing that Ruth Bader Ginsburg was a unique figure in American history. I've tried to suggest a little bit about that here. Indeed, if she had never served on the Supreme Court, I think that she would have been a person of historic stature. She was a leading legal scholar. She was the architect of an extraordinary litigation campaign that had enormous impact on the law. And Of course, then she wound up on the bench. But I think for me, I think about it this way. Justice Ginsburg's scholarship put her in the first rank of the legal academy. Her legal advocacy transformed the law. Then she went on to the bench and made additional significant contributions. She was not only, in other words, as Chief Justice Roberts put it after she died, a jurist of historic stature. She was also a scholar of historic stature and a lawyer of historic stature. There isn't anybody else like her. I can't think of anyone else like her in American history. Now, someone else has replaced her has taken her place on the court, but there was nobody who could really replace her. And I count it as one of the great privileges of my life and career that I had a chance to spend part of it with her and under her influence. Thanks.
Thank you so much, Jonathan. At this point in the program, for our last 15 minutes, we have time for a Q&A. As we're meeting today in the meeting format rather than the webinar, you have the ability to ask any questions that you have yourself. But in the meantime, I'm going to start us off with the first question, if that's okay. So, Jonathan, I was wondering, of the cases you spoke about today, which one, in your opinion, do you think has had the greatest impact in terms of creating legal precedent?
I'm not sure that I have a way of answering that. I mean, if you think about it, Reed, the very first case, had an enormous impact simply because it was the first one. And it's pretty clear that although Professor Ginsburg did not argue that case, that was a case that she profoundly shaped. There is almost no chance that the lawyer in Idaho who represented Sally Reed could have won that case in the Supreme Court on his own. This is no disrespect to him. It's just nobody had been doing these sorts of things. So in one sense, I think Reed is the most important case because it was first and it made everything else possible. I think if we could ask Justice Ginsburg, I think she might say the VMI case was the one that she took the most satisfaction from. And because that was a case that made clear that whatever verbal formulas lawyers and judges might use, it would be really, really hard to justify a policy that excluded women. And I think it's also worth noting that she didn't, it wasn't so clear that she was going to get to write that opinion, because the way the Supreme Court works is that the Chief Justice, if he's in the majority, assigns the opinion. And Chief Justice Rehnquist, who, by the way, when Professor Ginsburg was arguing her cases in the 1970s, was skeptical at best of her arguments. When he went along with her, he did so grudgingly and on the narrowest possible grounds, but he often disagreed and went the other way. Chief Justice Rehnquist gave her the opinion to write. Now, he wrote separately, but he didn't criticize her. He just said, I would decide this case without saying everything that the lead opinion says, but I agree with the result, and here's why. And that was just an extraordinary situation. And I think that reflected something about the way that she worked. I mean, as I said, Chief Justice Rehnquist had no reason to give her that opinion. He knew that she had a very different outlook on a lot of legal issues than he did, but they worked well together. They respected each other even when they disagreed. And when Chief Justice Rehnquist died in 2005, it's traditional for all the justices to release some kind of statement. Justice Ginsburg said, Chief Justice Rehnquist was the best and fairest boss I ever had. So, but I think that reflects as well something about how she interacted with people who disagreed with her. And that gives you and that helps to explain why she and Justice Scalia were so close, even though they were in such different places in terms of legal philosophy.
Absolutely. I was thinking about Scalia also listening to that answer. So a follow-up on that I'm curious about is, did you notice this when you were Justice Ginsburg's law clerk? Did you see this tendency of hers to be able to reach across the aisle and to work with people who disagreed with her then?
Well, you don't see that as much at the Court of Appeals level. And what I mean is that, when the cases get to the Supreme Court, they often involve intellectually, legally difficult questions. I mean, the Supreme Court is the last stop, and the court has pretty broad discretion over which cases it decides to hear. At the Court of Appeals, there isn't discretion. You have essentially a right to appeal to the Court of Appeals, and the great majority of the cases at the Court of Appeals are legally not all that difficult. So most of the Court of Appeals decisions are unanimous, not all. And yes, she did enjoy being on panels with judges who didn't always agree with her. And I will just give you one I don't think I'm violating a confidence with this. During my year, Robert Bork was appointed to the DC Circuit. He came on midway through the year. And the judge said to us that she was really glad that he was going to be on the court, because she said she understood that they were not going to agree on things, but she said, he's very smart and you can actually talk to him, even if you can't persuade him, and he can't persuade me on some things. But sometimes they could persuade each other. It's not like they were always in opposition. But so you get that sense as well, that she didn't take things personally. She wanted to have good, thoughtful discussions. She wanted smart colleagues, and she wanted to be able to get to know people, not just as somebody else sitting on the bench, but she had a lot of friends on the bench, both on the Court of Appeals and on the Supreme Court, even though she wasn't the most outgoing person in the world. But she kept her eye on the ball, but what was really important.
Thank you. So also speaking to that, to your time working with Justice Ginsburg in the Court of Appeals, Carol is asking from our audience, how long was your tenure as RBG's law clerk?
It was 1 year. Most Court of Appeals clerkships, and for that matter, most Supreme Court clerkships, are for 1 year. You come on, it's typically at some point in the summer, and in August, usually, early to mid-August. And then a year later, you move on to whatever comes next. Sometimes the clerkship might last for a second year. And there are some district judges who will hire a longer term clerk, but I think the typical clerkship is a year. You take that experience and you move on. And let me just say, I had a very good legal education, but I think I learned at least as much in the year that I was clerking with Judge Ginsburg as I did in law school. And that's not a complaint about my legal education.
So we have time for one final question. And so Jonathan, I wanted to ask you before we all say goodbye, if you had time, if you were able to distill from all of the wisdom that you've learned from Justice Ginsburg in her years of knowing her and in your years of teaching the work that she's done in the courts in your classes, what is the most important thing that you would say you've learned from the figure of Ruth Bader Ginsburg?
That's one thing. That's that's a real challenge. Keep your eye on the ball. Don't take things personally, even when you might have good reason to do that. When things went bad for her, she tried to stay composed. She always used to say, anger is a useless emotion if you let it get the better of you. You know, what's the old saw? Don't get mad, get even. But her sense of getting even wasn't revenge. It was, how do we get beyond this bad place so that we don't keep repeating the same mistakes that we've made along the way?
That really, for me, brings to mind the idea of tikkun olam, or repairing the world, the Jewish value. So what a wonderful answer. Thank you, Jonathan.
Thank you.
So, unfortunately, now that it is after 5 o'clock, we are out of time for more questions. I would like to thank absolutely everybody who participated in today's program and who asked questions. Thank you for joining us in a meeting instead of a webinar today for that little bit of extra interactivity. Thank you so much, Jonathan, for this conversation today. I know that I learned a lot. I hope that everybody in the audience did. And so thank you for sharing your own personal stories and just your knowledge of Justice Ginsburg and her jurisprudence with us. For everybody who tuned in through Zoom today, thank you again for taking time out of your day to be here with us from your homes. You can join us again for the final gallery talk of the summer, which is also the final program of the RBG exhibition on August 25th. Sabrina Harris of the ACLU of Ohio will be talking about the history of the Women's Rights Project, which RBG founded with the ACLU. You can find more information on this program, as well as upcoming programs and exhibitions on our website, www.maltzmuseum.org. Thank you again, Jonathan. Thank you again to all of our guests who are here tonight. Thank you all, everybody, and I hope you all have a wonderful evening. Take care.